Hello, my name is Elliot.
And my name is Alex.
And in this video, we'll provide you with an introduction to intellectual property or IP.
We're Ingentium, an IP management consultancy based in Edinburgh, Scotland, and this is IP 101. When someone mentions intellectual property, people often think of patents, law, solicitors and monopolies, but there's actually a lot more to it than that.
Intellectual property refers to property that individuals create through their intellect. Here's an example. If I use my immense intellect to create this piece of art, then this image is my property.
Or if I work in an organisation to develop a new process for producing human stem cells, then that process is the organisation's property.
When you hear us or others discussing IP management, this is simply referring to the process of managing any IP assets and rights that a person or organisation creates.
Sound IP laws and management create a fair and innovative environment where innovators and artists are fairly rewarded for their work and encouraged to create more.
In this video, we'll go through some of the most used and most misunderstood intellectual property rights. This includes how to protect your logos and slogans,
How to protect your software and data,
how to protect certain processes or skills that give you a competitive advantage,
and how to protect new inventions. Firstly, we wanted to be clear on some terminology. When talking about intellectual property, you often hear the terms IP assets and IP rights. While they might sound similar, they're referring to two very different things.
IP assets refer to the thing that has been created, whether it's an invention, a book, a process, or some computer code. These assets often carry a commercial value and a strategic advantage.
Whereas, intellectual property rights refer to the rights that the owner of the asset has. Examples of intellectual property rights include copyright and patents. These intellectual property rights are what legally protects the creator or the inventor. A trademark is used to show a claim of ownership over a word, sign or symbol that is associated with a product, service or brand.
That means that a trademark could be almost anything as long as it distinctly distinguishes a brand. The most obvious example of this would be a company logo.
They are often one of two symbols. The TM symbol means that the company claims the image as their own intellectual property, however, it is not officially registered. The R means it has been officially registered. Registering a trademark provides further legal protection and means the trademark can also be licensed or sold to third parties.
Here you can see I'm at McDonald's surrounded by trademarks. The McDonald's logo is an obvious one. The slogan, "I'm loving it," is also a trademark. Almost every menu item has a trademark, including this Big Mac. Copyright is a legal term used to describe the rights that protects a creator's work and prevents others from using it without a creator's permission. An example of this would be the drawing I created earlier.
Copyright protection is obtained automatically as soon as an original idea is expressed in some physical form. Once obtained, copyright stops other people from copying, distributing, or showing your work without your permission.
Copyright is most commonly used in fields such as music, theatre, marketing, films, graphic design and web design. In recent years, it has become more prominent as it can also be used to protect software and databases.
Software such as apps and computer programs are generally considered as literary works and are therefore protected through copyright. You can use patents to protect your software, but it must meet all the required criteria. We'll tell you more about that later.
Databases are also protected by copyright if the data is original. Alternatively, they can be protected through database rights if there has been a substantial investment put into creating the database.
Database rights prevent people from using the contents of your database without permission. Copyright protects all these works from music to computer programs for 70 years after the death of the author. That means anyone wishing to make use of Eliot's piece of art or any other copyrighted work should seek permission from the owner, who will then give them a license to do so.
There are two kinds of rights associated with copyrights. Firstly, the economic rights ensure that the owner can make commercial gain from the success of their work.
And secondly, the creator gains a moral right to their work. Moral rights protects the creator's non-commercial interests, such as the right to be recognized as the author of the work. Trade secrets and know-how refer to confidential information or processes that give an organization a competitive advantage.
While they aren't registered forms of protection, they can be just as valuable, as they can be used to underpin a business strategy.
First of all, trade secrets and know-how are not the same thing. A trade secret can constitute as any sensitive information which provides a commercial advantage.
The trade secret must be acknowledged as a trade secret, and the organisation must show they have taken all reasonable steps to protect it. Some examples include the Google search algorithm, the method for ranking the New York Times bestseller list, and the Coca-Cola recipe.
Trade secrets are a common alternative to patents, as they provide some of the same benefits while keeping the invention secret, potentially forever, and they're practically free.
KnowHow, on the other hand, refers mostly to the organisation's ability to create value specifically with regard to its workforce.
An employee carries with them knowledge, skills, and experience, which is an intangible asset.
This asset can be one of the most important assets to a company. Good know-how provides significant competitive advantage while attracting potential customers and investors.
As with any asset, it must be managed and monitored. Usually, contractual stipulations are used here as a method to minimize the amount of know-how that leaks from the organization.
It is therefore important to record and maintain know-how as confidential information, so that if people do leave, the know-how doesn't leave with them.
Know-how is therefore usually managed using a combination of HR practices and contract law.
Patents are perhaps the most well-known type of IP rights. They are rights granted by the government to protect technical inventions. While the application process can be lengthy and costly, patenting an invention has many benefits.
Patents can improve market power and provide an organization with a competitive advantage. They can also be licensed, meaning they could create a new source of revenue.
Patents are a territorial right, meaning they only apply in the region where they are granted, so one invention could have multiple patents.
To be granted a patent, the invention needs to meet three main criteria, or the three N's. Firstly, it must be novel. It has to be new and original and not within the public domain. Secondly, it must be necessary or have a prospect of commercial application. Thirdly, it must be non-trivial, meaning it can't be obvious.
There are a few notable caveats, however. Some things are not patentable. This includes artistic works, ways of doing business, medical treatments, scientific discoveries, and a biological process.
While patents can provide commercial and strategic benefits, the process to get them is long and can be costly.
It usually takes years for the application to be granted and can cost up to £20,000. In the UK, patents are valid for 20 years.
In the time period between the initial application and when it's granted, the invention is classed as patent pending. In this time period, others cannot apply for a patent covering the same invention.
Around 90% of patent applications are successful. If the application is successful, it is then possible to claim the profits of any other companies who sold the invention.
For this video, we decided to go to a local supermarket to see if we could find some examples of patent-protected products.
However, our mission was slightly unsuccessful. Most of what the supermarket sells was invented more than 20 years ago.
Meaning that most of the products here are no longer patent protected. This allows the supermarkets to sell generic alternatives.
An example of this is this Morrison's paracetamol. The patent for paracetamol expired, so a number of brands have been able to make cheaper alternatives.
However, something that a lot of people do own that is heavily protected by patents is a smartphone.
The Apple iPhone, for example, has more than 200 patents relating to it. These patents cover inventions like Face ID and 3D Touch. Thanks for watching this IP 101. We hope you found this educational and at least mildly entertaining.
If you have any questions about IP, then please comment down below and we'll do our best to answer them.
And if you want to learn more about our services at Ingentium, please visit our website. The link is in the description.